extension, as Ms. McNeil, had you look at before, that had like a merger showing that lot T1 goes all the way out to Craigmore Road.
There's sewer easement going out there.
But there's no extension of the plan. Similar to what you see, and I'll just draw your attention back to Exhibit F, which is the 1997 plan. Where it shows parcel B. Can you compare that?
Yes, because I'm not seeing parcel B on this plan.
Do you, Andy, do you have this plan, or do you want me to show him mine?
Which one?
Well, I'm trying to get him to see parcel B,
That's from your house.
and I'm asking him if it's on the plan.
Stacy might have, Stacy has the large size.
It's with the board right now.
Plan.
Mr. Marks, look at that for a second to compare it with his plan.
I need your consent on a few items to continue.
Somebody's talking to you.
Again, I'm looking at a condition of this plan, this here in 1999, subdivision.
Right, we're just asking where is parcel B on this plan?
Can't answer that, on this plan here. There is no parcel. One condition.
And is there an extension of T1 out to Craigmore Road? Because Ms. McNeil showed you that this Z could be a merger of lots. So that would take T1, if it was a true merger, and make it go all the way out to Craigmore Road, passing lot 5 and lot 4, which you have on your plan.
Can you show me lot 5 and 4 on this plan?
Well, lot 4 is right here. If you look at this plan right here, lot 4, parcel B is right next to it. So there's no,
Again, it's a separate plan.
okay. I mean, we're just saying that parcel B, you will testify that parcel B is not on that plan.
I don't see it on the plan.
Which plan is that?
His
condition-
plan that he
the-
has, that was.
Could we have this admitted as an exhibit? This is the conditional use plan.
That is your choice, yes. This will be Township Exhibit number 3.
Yeah.
I know, I've seen it small, but
I don't think
I don't. There's a conditional use plan.
We have the final subdivision.
So this is a final subdivision, and this is a final subdivision.
it goes all the way out to Craigmore Road.
Is there a lot A on there? Or, I'm sorry, a parcel A?
This is going to be Township Exhibit number 3, correct?
Yes.
Oh, it's, yeah, but
This isn't one we had.
we had this one, yeah.
No.
Which is the 2010 conditional use plan, correct?
2003.
2003.
Excuse me, I'm sorry, February 2003, conditional use plan. Now it's correct, right? Okay.
Mr. Martin, review of your conditional use file, was there an updated plan after February 10th, 2003 for the conditional use application?
Not in the conditional use plan.
Isn't it true that Mr. Toomey and Mr. Allen Toomey original submission was denied for his conditional use?
That's correct.
Is this the plan he submitted with that original conditional use application?
Are you talking the February 10th, 2003?
Yes.
That was the plan submitted for 2000.
Okay. Is there any record in your file saying Supervisor Toomey abstained during that public hearing that was held on the conditional use?
The only minutes that I was able to locate was the Board of Supervisors approval of the plan, which was exhibit to me, number 1, it was provided to me on June 24, 2003. That's the only information that I was able to locate.
Mr. Martins, I'm assuming you're familiar with your zoning ordinance, is that correct?
Yes.
I'm gonna call your attention to the joint. I'm gonna first start with the, apologize, I'm gonna start with the 1998, or 1988 zoning ordinance.
Did you have a copy of it, what you're referring to?
Not, Andy still have his copy
But
there?
without looking, I am not familiar with the 1998.
Okay. All right, then I just won't ask you that question,
He does have a copy.
I have a copy of it, but I am,
but you're not familiar with it.
no, not
Okay.
unless I wrote it.
All right. Have you been involved with any other, conditional uses while you've been employed with the township, has there ever been a building permit for a residence on that lot, other than the one you issued in 2020? I'm gonna ask you to refer to section 608. I want you to look at the last sentence of 608. You know that if the setback and lot coverage requirements are met, like Mr. Tucci's building permit.
Based on what was provided to us, we rely on the information that was provided.
Um, Oh, one further question. Mr. Marks, when did you receive my client's application contesting Mr. Toomey's building permit?
The application, for the appeal was filed on June 25th, 2020.
And was that within 30 days of you issuing the building permit?
It was.
Mr. Marks, if I may, a couple follow-up questions. Do you have an understanding as zoning officer how you're to interpret zoning provisions if there's an ambiguity or a conflict in the ordinance?
I'm not, I usually, refer to our attorney if there's questions.
Township 3, which was the conditional use plan that was referenced, I believe was indicated was dated February 10th, 2003. Do you know when the conditional use application was filed that was denied?
There's an application filed, July 15th, 2002, requesting a conditional use.
So at that point, this plan dated February 10th, 2003 was not in existence. Is that your understanding?
When it was denied. That is correct.
The subdivision plan from 2003 that you see here, and T3 is lot T1, which was owned by the Herring and the Greens. Was that the subject of this subdivision plan or this conditional use application?
That's what was presented.
T1, their property, was the subject property of the application? Or was it T2, the subject of the application, approval for T2 to be subdivided?
T2 was the conditional use plan.
So let me give this one more shot here, and we won't waste a lot of time with this. So I'm gonna show you applicant's exhibit F from the application, and I'm gonna show you T3. So let's start with applicant's exhibit F, which was the plan, the larger size plan I showed you. And you've identified on here lot T1, right?
Correct.
And parcel B, right?
Yes.
And a lightning strike between the two. Okay. So you see what they look like? Now I'm gonna show you T3 here. Oop, let's make sure it's going the right way. Now look at that shape of lot T1. Do you notice anything about the shape of lot T1 as compared to the 1997 subdivision plan?
It was merged.
It was merged with what?
With parcel B.
Yes. So you're understanding that lot T1 is shown on T3, the exhibit, township 3, includes parcel B.
That's correct.
Now, this doesn't show T1 all the way out to Craigmore Road, right?
That's correct.
Because T1 wasn't the subject of this conditional use application, is that right? Okay, then you have no further questions.
I have to follow up. This exhibit is the overview provided by the Toomey's attorney. Mr. Marks, do you see T1 extending out to Cragmore Road on this map?
Not on that.
Not on that. Is this the plan that was approved with the minutes that you provided on June 24th, 2003?
Saying June 24th.
I think it was June 24th was the date of the minutes that you said it was final, subdivision was approved.
That is correct, that is what was approved.
So there is no parcel B or lot T1 going out to Cragmore Road.
There's
on the
access
plan.
to it, it's not,
But the parcel B that extends all the way out to Cragmore Road, as you saw in the 1997 plan, that Ms. McNeil just said was merged, is not in this overview. This plan does not show T1 extending out to Cragmore Road,
other than having access.
just the joint access road. Nothing further.
I'm sorry, Mr. Marks. Oh, go ahead.
Can I just like to clarify one thing with you, Mr. Marks? So, on this 1997 plan, the lot lines are shown with a dot and then two dashes, correct?
That's correct.
And there's essentially shown parcel B as a flag lot going out to Cragmore Road, and lot 4 has a parallel flag lot going out to Cragmore Road,
That's
correct?
correct.
On this subdivision plan in 2003, the lot lines are shown with a double dash and then a longer dash, correct? You see a double dash and a longer dash on the lower part of the blue that's circled as lot 2. Where do you see the double dash within the right-of-way area extending out to Cragmore Road?
It's right away there.
So do you, if you look for that single line and then the double dash, do you see 3 single lines and double dashes at Cragmore Road indicating 2 flag lots coming out of Cragmore Road?
Let's see, give them access.
Do you see, is there a double dash on the lot H4 side extending the whole way back to lot H4 from Cragmore Road? Do you see that?
There is.
Is there a single line with a double dash in the middle of the joint use driveway extending the whole way back to the end of lot T1?
There is.
Is there a double dash perpendicular to that flag line on lot T1? Perpendicular to the joint use driveway towards Cragmore Road? Do you see any double dash extending across the joint use driveway, or does it turn right and go back towards Cragmore
It
Road?
turns right and goes out.
And so if you follow that single line and double dash, that extends the whole way out to Cragmore Road.
That's correct.
So this lot T1 is actually shown as a contiguous lot the whole way out to Cragmore Road.
That's what's showing on there.
That's all.
I have one more. Sorry. Mr. Marks, on Township 3, you provided, Township has provided for, can we see
proposed number of lots are 3.
You see here it says proposed units of occupancy, 3.
Yes.
So, wasn't the plan that was disapproved for the 2 units, that was denied, proposal for 3 lots?
The plan that was denied. That was for 3 lots in 2002.
Okay, and this plan also, just for the board, can you tell me what is listed all over T two, fine print? Or if you wanna look at your bigger one,
You're still looking at 2000.
yeah, you can see it here,
Okay.
it's real big there. What's it say?
Entire tract is wooded.
And is that all over T two and lot 1?
It's indicating on there, the entire tract is wooded, and it's also indicating some slopes.
Is there any, notation in lot 2 that says that it is all wooded?
Not on this plan, no.
So it's only on lot 1,
That's correct.
which we have identified as Mr. Chimmy's lot, is that correct?
That's correct.
Thank you, no further questions.
I have a question, Jeff. I see a note, handwritten note on, I'm assuming it's lot T2. Over by the Cy Road right-of-way. It says subdivision plan, no access allowed from former Cy Road lane, right-of-way. I'm assuming R-W is indicating right-of-way.
That's correct.
Why would they notate that, you know, the subdivision plan, no access allowed from former Cy Road lane?
Well, there is a note on the plan here, and I don't know if you have that, where it says Cy Road Lane was abandoned by the township, adjoining owners,
Yes.
maintained. The Stone Road, no agreement has been made. Other than that, I don't know why it was denied at the time.
I'm just, is it because they planned on having access from the joint use driveway is my only thought as to why that notation would be made there. Other than, you know, we don't know, since there's no minutes, what exactly
Yeah, there's no minutes in here,
other than they approved the subdivision.
that's correct.
And your issuance of the building permit was based upon the supervisor's approval of the subdivision.
The conditional use and approval of the subdivision, that's correct. The recorded subdivision.
And I'm sorry, again, that was, the conditional use plan was approved, well, at least it was, is the approval February 10th, 2003?
April 14, 2003.
Okay, so, this plan's dated February 10th, but the actual approval was April 2003. Is there any other questions?
If I could, I have just one question to follow up the last line of questioning from and that, Jeff, Mr. Martz, if I could ask you to go to the conditional use here, file that you have, 2003.
Okay.
And you have a copy of the application that's in there.
I do.
And could you go to item number 4, the application? Should be on page 2 or 3. Could you just, read what that says?
4B, items per section 441 of the zoning ordinance. Letter B, section 414.4, 2 lots proposed with a density of 1 unit has 7.2 acres.
So, just to clarify, this would have been the conditional use application that led to the April conditional use decision.
Yes.
And the application itself was requesting 2 lots.
That's true. That's correct.
We'll submit this as township report.
Yes, that would be correct. Is that the copy exhibit 4?
gave the stenographer a copy of.
Okay. This is township number 4. February 3, 2003. Letter of Viscon Land Survey to Mr. Piper, Chairman, correct?
I have no further questions.
Pardon? Can't hear you. Any other questions, any other witnesses? Any other questions by the board?
Any other questions?
Then closing, no. Closing remarks?
Do you want me to come to the podium or something?
Yes, yeah, it's probably best if we can, because it's being recorded.
On behalf of Shane Herring and Leanne Ream, I would like to thank you for your attention tonight. It is our contention that the building permit issued to build the residence at 160 Cragmore Road should not have been provided in accordance with your ordinances. Specifically, we'd like to draw your attention to a few key facts that you heard testimony about this evening. First, Parcel B has not been identified on the plan. That is a matter of contention for all of us. And the issue that it does not go out to Cragmore Road has been hotly contested tonight. The next issue is that easement agreement from May of 1998 was not identified in the building permit nor in any record for the conditional use application in 2003. We feel that those pieces of evidence were not provided to the township, so they didn't have the use of that information while making their decisions. The letter that we provided as exhibit, I think it was Exhibit A from John Harold, specifically said that the township zoning and subdivision land ordinances should apply and shall be followed. In your subdivision and land ordinance, you heard testimony tonight. It says all lots shall have road frontage. That was the current subdivision and land ordinance that was in place. We're not trying to show you ordinances from tonight for that purpose. We are going back to that ordinance, which you have a copy of. There is nowhere on the plan, you heard testimony, there was ever a waiver for road lot frontage. Nor was there a waiver for any type of use for 5 properties. We do not know for sure if those properties were ever merged or in terms that the lawyers like to use, reverse subdivided. If those lots were reverse subdivided, we would have some type of record in the township's records showing that reverse subdivision. Yes, they can be merged, as Ms. McNeil pointed out with that little Z, but there was no application that we know of that those lots have been merged. In the deed for Ms. Ream and Mr. Herring, it identifies parcel B and lot T1. It even says it in the being clause. It points them out and says the plan to go back and look at those. We know that this is a rural cluster, and we know that your zoning ordinance, because we've heard a lot of talk about it tonight, says that a joint use driveway cannot serve more than 4 individual dwellings. In your subdivision and land ordinance, it says lots. It does not say dwelling lots. So there's an ambiguity in your ordinance. One of the things that I would like to point out tonight is that in the conditional use decision from the 2002 submission by Mr. Toomey, it indicates that the applicant believes that the proposed development will preserve woodlands by establishing large acre tracts with only 1 residential structure per lot. If the large-style tract development were proposed for this piece of land, the woodland would be destroyed in order to install roads, houses, and other improvements. Isn't that what we're doing by issuing the building permit? You heard testimony tonight that the woodlands are being destroyed. They're being cut down. We feel that with all the evidence that this building permit should not be issued. But to further that, we heard Attorney McNeil say tonight that this lot was non-conforming. We also heard Mr. Martz say that this is a non-conforming lot. Well, your ordinance today, the 2006 zoning ordinance, which was amended, and there's a lot of other dates associated with it, says that if that non-conformity isn't used within a year, it's abandoned. There's been no house on this property. There's been no building permit on this for this property, except for an accessory use storage shed, and now a building permit for a residence. It's our contention that this conditional use that was applied for in 2003 has been abandoned. You heard testimony tonight from Mr. Martz and Mr. Herring that my client did submit his zoning application appeal to the building permit within the 30 days required. They did their due diligence. Now it's time for you to do yours. And we respectfully request that you do what the MPC has you do what your ordinance has you do, and deny the building permit to Mr. Toomey. Thank you. Nothing further.
Good evening, Board. As I mentioned, my name is Stacy McNeil, and I appreciate your substantial time on this application tonight. So what we have in front of us tonight is, by all accounts, a collateral attack on a 2003 conditional use approval by the Township Board of Supervisors and a 2003 subdivision plan approval by the Board of Supervisors. This is done as a collateral attack through the appeal of this building permit because the time has certainly run for appeal of those 2 actions. How do I know this is a collateral attack? Well, Attorney Snow-Dubs just told us. She said the building permit shouldn't be offered because the conditional use application didn't include a reference to the 1998 easement, and so we don't think that it was presented to the board at that hearing. The conditional use application shouldn't have been granted because the plan doesn't identify parcel B. The subdivision plan shouldn't have been approved because there doesn't appear to be on the plan a waiver of road frontage. These are the reasons for the building permit denial that they are requesting. So they're essentially saying they don't think that the supervisors should have approved the conditional use or should have approved that subdivision plan in 2003. Now, I don't know all the discussions that happened with the supervisors at that time, and I dare to say, even if we had minutes, I don't think that we would know what those discussions were, based on the brevity of the minutes that we've seen for the meetings that we do have. We know there's no stenographic record. That would be typical if there was no appeal. We do know that there was public notice of the conditional use hearing, and none of the neighbors who received that notice appealed that conditional use hearing. The applicants tonight had a title search done when Ms. Ream purchased her property. She testified to that. Back in 2004, there was a title search. Whether she recollects it or not, part of the record at the courthouse would have been the subdivision plan that we're looking at that shows a proposed dwelling on lot T2. Says specifically that lot T2 would be using this joint use driveway as access, and that there was a conditional use approved for the use of that driveway. They also had in their record at least 2 access easements, one of which specifically referenced access by this lot T2. I'd also know, because there seems to be some confusion on it, Parcel B was merged as of record, so there is a recorded subdivision plan from 1997. Part of it was creating new lots, part of it was merging Parcel B with Lot T1. That's why we don't see Parcel B identified anywhere else, and it's why in both of the easement agreements, when it talks about access to the various lots, it talks about Parcel B and or T1. Acknowledgement that they were at that point one lot, never to be separated, not separate dwelling lots, not separate building lots. So, so then what do we have? What's been presented that doesn't really have to do with the merits of what was presented to the supervisors in 2003? Well, the question becomes, can a conditional use application, I guess, expire? They'd have you think it could be abandoned. And while I agree that Mr. Martz testified that he believes that this lot is a non-conforming lot, I don't believe I ever testified to that. I did ask questions about that provision of the ordinance, but I didn't make a determination to that effect. I don't believe that there's anything that says that that subdivision plan, which is recorded and clearly allows for a dwelling on the property, expires or is abandoned. And what you do have in the ordinance, if you want to believe it's a non-conforming lot, again, I think there's a distinction between a non-conforming lot and a lot that was specifically approved to be this way by conditional use in a subdivision plan. So if you want to consider it to be a non-conforming lot, you have one provision of the ordinance that says, in section 704, that if you've got a lot of record when the ordinance is enacted, you have to be able to build a home on it, period. And this lot was clearly in effect. It was of record when this ordinance was created. The provision that she's relating to, section 60, let me make sure I get the right one, 602, very specifically is talking about non-conforming use of land or of a building or structure. So if you've got use of a land, so I'm using my land for a restaurant, that's no longer conforming, I'm now in a residential zoning district and I don't use it for a year, then I lose it. If I've got a building and it's way too big and your ordinance wouldn't allow it anymore and it gets destroyed in a fire and a year and a half goes by and I want to rebuild it, I've lost it. Doesn't say that if you have a non-conforming lot as to size or lot width that you can't put a house on it. To the extent maybe you think there's a conflict in your ordinance, I'm sure you're aware of section 104. It's also right out of the MPC. It basically says, to the extent there's an ambiguity in your ordinance, you must resolve the ambiguity in favor of the property owner. In this case, that would be Mr. Toomey. So ultimately, I believe that we've spent the past almost 3 hours here tonight in a collateral attack on 2 decisions by the Board of Supervisors from 2003. I understand the applicants aren't happy with the decision the board made at that time, but neither does this board, in my opinion, have the authority to reconsider those decisions that were made at that time. And essentially, that's what the application in front of you is attempting to do. Thank you.
Thank you all as well for your time this evening and thoughtfulness and the thoroughness with which you've looked at this issue in this application. Section 707 of the zoning ordinance has a 30-day time limit on filing these kinds of attacks on a subdivision plan or an approval, such as a subdivision plan, for a very good reason, and you're seeing that tonight. Going back and recreating this record and figuring out what was done back in 2000, 2003 is a monumental task, and there's a lot of guesswork involved in it typically. There's a lot of things tonight that have been disputed, have been brought up numerous times in different ways, and really have made it, I think, difficult to understand what happened back then. That's why we don't go back and look at those applications. They're that long. Look at those subdivision plans and take a second guess, I guess, of what was done back then or said or what record was created. The township's here because doing that and holding the zoning officer to that kind of a standard is unmanageable for the township. Does this mean what the applicant's requesting, that the zoning officer, every time he receives a building permit, has to go back and scrutinize all of the past history of a subdivision plan, a final plan that's been recorded and of record for 17 years? It's an unreasonable standard for the township to live up to. In this case, there was a subdivision plan recorded. It was approved by the Board of Supervisors. Whether or not they didn't list waivers on it, or they could have listed them in a different way, could have been more clear about certain things, it's past the time to challenge that. And that was the same Board of Supervisors who would have granted that waiver. So at the end of the day, they approved this plan. It has a proposed dwelling shown on it. I think Attorney McNeil discussed Section 608 of the zoning ordinance, which is what applies to non-conforming lots. And I think even if this were considered a non-conforming lot, what would apply here? I think discussion or referring to Section 602 abandonment, that section clearly applies to uses and abandonment of a use. This use is a permitted use in the rural residential zone, a residential use. It's not a non-conforming use. So Section 602 just simply doesn't apply in this case. I think the last thing, and I think one of the clearest things from tonight that's been developed, and I know there's even dispute about this, but I believe it's very clear that that 1997 subdivision plan that had the lightning strike on parcel B did reverse subdivide that, merge that into lot T1, and I believe the plans after that were consistent in showing those property lines. If you look very closely at those plans, it gets very confusing because there's a lot going on with all the different easements in that panhandle, but I believe if you look closely, the lot lines are consistent with that reverse subdivision. If that reverse subdivision occurred, and quite frankly, even if it didn't, parcel B was never a dwelling lot. It was never configured to be a dwelling lot. It would have been virtually impossible to fit a structure onto it as a dwelling lot. It was intended as an access. The ordinance in 1988, the 1988 ordinance, it applied when the conditional use was approved and the plan was approved, clearly referenced a waiver of the frontage requirement for joint use driveways with no more than 4 dwelling lots. Even if that other right-of-way existed, and I can't speculate as to why that wasn't disclosed or known, but even if it did exist, there are no more than 4 dwelling lots approved to use that joint use driveway, lot T2 being the 4th of those. There's either parcel B that was simply area for that access and not ever intended to be a dwelling unit. It wasn't counted separately for maintenance purposes. There was lot T1, which that was, it looks and appears from the plans, intentionally merged into. There was lot, I believe it was H4 and H5 and T2. That was a total of 4 dwelling lots that were using that joint use access. So the township does not see any problem or any exceedance of even that requirement if you even get there. But again, at the end of the day, what the township is most concerned about is setting a precedent and a standard that the township zoning officer just can't realistically live up to in the future, and going back and scrutinizing these plans in this way before issuing a building permit. There's a final subdivision plan recorded and filed, and it hasn't been appealed. That's a final plan, and the zoning officer can rely on that plan to go forward and issue a building permit. Purchasers can rely on that to go forward and purchase the lot, and they can rely on that to submit a building permit and build a house on that lot. So we just ask you to give that careful consideration this evening, as I know you will, and thank you again for your time.
This was somebody's copy.
Yep.
I don't wanna
If you're done with it, I'll take it.
Yeah, I don't wanna
Thank
take
you.
it back,
Do we have a motion?
so. Ready? Talk about it, or you have a motion? We can recess for a moment.
I'll make a motion to recess for a moment.
And deliberate, or
We have a motion to recess. Do I have a second?
I'll second.
All those in favor say aye.
Aye.
All those opposed, nay. Hearing none, the motion passes. Newberry Township Zoning Hearing Board is now back in session. After consideration of all the evidence and the presentations, do I have a motion?
I'll make a motion to deny the application.
All those in favor say aye.
You need a second.
Oh, I'm sorry, do I have a second?
I'll second.
All those in favor say aye.
Aye.
All those opposed, nay. Hearing none, the motion is denied. I'm sorry. The
Motion is accepted.
motion is accepted. Thank you, everybody. We will now be hearing docket 20-05, Burgett and Associates Incorporated, 1797 New Bloomfield Road, New Bloomfield, PA, 17068. Applicants have filed a request for for a variance from section 514.3, buffering of the zoning ordinance to reduce the minimum required buffer yard from 50 feet to 9 feet for commercial use of an existing dwelling as veterinarian offices. The property is located in a regional, commercial/office zone at 1640 Old Trail Road, Edders, PA. Tax map PG, parcel 0101 alpha. Mr. March, you were already sworn in previously.
That's it.
Was the property posted?
The property was posted on August the fifth, 2020. Area neighbors were notified on that same date. It was advertised at the newspaper company on August fifth, August 17th, as well as the Newberry Township website and the Newberry Township Administration bulletin.
Thank you. Is there any additional information you'd like to give the board?
Not at this time.
Excellent. Anyone here to give testimony for or against, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Joe,
Would you mind stepping to the podium, please?
Good evening. I'm Joe Burgett from Burgett and Associates. I'm here representing the owner of the property this evening for the zoning variance. Want me to start? Go ahead and give you what I have.
Yes, sir.
Okay, I have some exhibits that are outlined here and labeled that I'd like to hand out. I'd like to go over with you. These exhibits are A1 through A4. These exhibits, A1 through A4, are basically a tax map representation of the property, some aerial photograph of the property, some road views, like if you're driving down the property, what it looks like along the edge of the road from Google. If I may, I'd just like to hand out all these first, and then we can go through them. Is that okay?
Yes, sir.
This would be A5. This is a copy of the zoning ordinance, Newberry Township zoning ordinance, related to buffering, which is what we're asking for the variance for this evening. That'd be A5.
Thank you.
A6 is a blow-up of the zoning map. Newberry Township zoning map. With the site outlined on the zoning map. A7 is the actual entire zoning map. Newberry Township zoning map, A7, with the site also shown and labeled.
Thank you.
Okay. For you here, I have a map that was attached to the application when we submitted it. What I did was just highlighted some areas just so for presentation purposes I could point, shoot, do some things here. What we have is the site, this is Old Trail, right down the road here, not too far. And then this is 83. So we're sandwiched between 83 and Old Trail. Property currently is two different tracts of ground that is actually has an existing home which sits right here. This is an existing home, residential home, with an existing well and existing sand mound here. What my client would like to do is build on an addition on the south side of the existing home. Convert this home into an animal hospital. Okay, they currently have an animal hospital up here at Walmart. They're going to be relocating here. Okay? So based on the square footage of the building, the existing building and the new addition, I need to have so many parking spaces. The parking requirements say I need to have so much per square footage plus additional spaces for employees. So based on the calculations, I need to have 16 parking spaces. And with the current building being here, and the property line being there, and for me to squeeze in 16 parking spaces, I'm very limited in space. Okay, so right now this pink area represents the area on the north side of our parking lot we're asking for the board to reduce the buffer from 50 feet, because the requirement in the ordinance is 50 feet buffer, to 9 feet, because it's all we have. I can't add any more. I need the parking. The house is here, the property line's there. I'm stuck with that. I can't put the parking anywhere else. There's an existing driveway that comes in here right now to a concrete pad, and we're just in a really nice flat area to build the parking lot. So what we're going to do as far as stormwater, we're going to take the water, put it in inlets, and come down here and build this detention pond to handle the stormwater requirements of the ordinance. Okay, so 1 acre lot, very, very, very small, compact, sandwiched between the building and the property line. I can't put the 50-foot requirement there. So what we'd like to do is build a fence, 6-foot high fence, and put as much evergreens in there as much as they can within that 9-foot area. Now, so if we look at, I just want to review one thing with the A5. This is the requirements in the ordinance for buffer. If you look at A5 that I gave you, I highlighted some things. At the bottom of this, it says section 514, section 3. A buffer yard and screening shall be provided between districts and uses as follows. You flip the page, top of the page, item number A. This is the requirement in the ordinance. A buffer yard of 50 feet shall be required between residential uses or zoning districts and non-residential uses or zoning districts. Okay, so I need to have that buffer if I have a residential use here, okay, or if it's a residential zone. Okay, so if you looked at A6, everything in orange, it's all zoned. Everything around here is zoned in the same regional commercial office. So all these lots here are all zoned the same. So that different zone is doesn't count. It just doesn't apply. So it's only the residential use that creates me having this, to create this buffer. Okay? Only the residential use. So we got to prove there's residential use there. I'm not honestly proven, I don't think there's a residential use there. That's why I gave you a couple of these exhibits for A1. A1. Tax map for York County. Clearly, you can see, I put on here buffer. That's where we're proposing our buffer. The tax mapping is completely wrong with property lines on this map, but it is a good representation of what's next to us. So you can see on this map, I have the buffer line. That's where this is, right here. Okay? To the north of that, there's a field. See that on the map? Grass field. No house on that field. Okay? No house there. Across the road and that property is all deeded as one. So this field is part of the same deed as that house across the road. Okay? Okay? Now, if you look at this A5 again, second page, item number 5. The buffer yard shall not be required in front yards. Because why buffer a street? Okay? The ordinance says that. Why buffer a street? That house is on the other side of the street. that residential house, I just pointed at from the other side of the street. So no buffer is required between that house and my property. Now, it is required if that's a residential use in that field. It is required. Now, if you go back to A4, this is a street view of this property. This is the field that we're talking about right here. I have labeled billboard. The billboard on that lot, right in that field. Field, you rent that, right? You rent that space, commercial, use. There's no house there, we just said about that, you don't have buffer because of the other street. But there's a billboard here. So that's being used right now commercially, in my opinion, because that billboard's there. They get rent from that billboard. Okay, so ultimately my take is we don't have to do a buffer because you don't meet that residential use requirement. My opinion, but my client says if you guys think it is, we'll do the best we can, we'll put a fence there. I don't think my client's actually responsible, required to put a fence there. That's my take. That's my take. No house there. It's a grass field. Billboard on. Currently being rented out. And no I don't think there's a residential use there. That property has a residential house across the road, most definitely, but I'm not required to buffer that. So my whole take on variance is nothing. Because no residential use. But if you guys feel differently, my client's like, I don't want to, I'll put a fence up. That's what we need to do, we'll put a fence up, put another green trees along there. Again, I don't think they're required to do that. If they want to do it, they don't.
Just to get some basic information,
Yeah.
You've already described to the north, there's a field with a billboard.
Yeah.
To the south of your property, what is it in the south?
There's
To the
nothing
south.
there. There's a very, very narrow quadrant. This property line's only 53 feet wide down here. This is where the culvert comes across from 83. So there's really nothing being used over here.
What about to the east of your property?
The east would be 83, and then the west would be Old Trail.
And you described there's a well, a pre-existing well on the property?
There is one here that's outside the current house. When they built this building, they're gonna have to probably cap it off and make it flush the concrete door and everything to do inside the building to make that work. But there is currently a well on the property.
And the septic is a sand mine?
There's a sand out there, yeah.
Jeff, this is regional commercial, right?
That is correct.
All right, no residential uses are in regional commercial, right? I'm looking at the ordinance here, and I'm not saying that that's a permitted use within regional commercial. The property across the street is a home, okay, so that's a non-conforming existing residential use, assuming it's a residence, okay? Would they be able to move that residence from across the street to next door to this animal hospital on that same property? Now, I grant you, if you look at the size of the home, that's not very likely to happen.
It's not likely to
Right.
That's all owned by one person.
Yes, sir.
Both sides of the road.
Yes, sir.
It's all Bay Shores on farm.
Mm-hmm.
Yeah, but Green Road, the other part, maybe.
Brownie.
But yeah, that was part of Bay Shores there.
I'd question too, whether or not is there enough room to build a home on that side?
Probably would be.
Probably just enough, yeah. Well, you look at a situation where the house burns down. I'm not saying that it will, but you have some catastrophe that happens to the house and they're able to rebuild that home. They'd have to move it across the road, they'd have to put in a septic system, right? They'd have to have a well for it. They could possibly do that there. Now, why you would, I don't know, given the location.
But currently it's not.
Right, no, it's not there, that's correct. When was that house built, do you know? How long has it been there?
It's
Two.
old.
It's
Long
old.
time, long time.
Does it
1800s.
predate, does it predate 1980?
Oh,
Yeah,
yeah.
if you look at the picture
It's
A4.
1800s probably.
Okay.
If you look at that picture in A4, it's a beautiful brick home.
Yeah,
It's
it
been
is.
a long time.
Yes. So it's more than 100 years old.
Oh, yeah.
Oh, the one they ran, changed that, it was, Leeds, yes, that's what the same property was, right? No. No, it's a different property. I know it is up there. No. Bayshore Farm is the rest of it. This was Reed's, yeah.
This property actually crosses 83 as well. That property owns lands on the other side of 83 as well.
Worthless.
Now, if you look at your A1,
Yeah.
it shows, the word site is listed there.
Yes, sir.
And that's where your home is, or that's where the home is that you're converting to the regional commercial
That is
use.
correct.
Across the street, those are homes there as well, is that right?
Yep.
And then up on the far north end, close to the ramp up there, there's some structures or buildings there. What are
I would
those?
assume they're residential homes.
I think that's a business, isn't
I think
it?
that's a business.
They're residential homes or apartments.
We're up by the ramp.
Apartments, okay, because they're owned by some,
This up here, that's.
yeah, building and something.
Somewhat.
Okay.
But those lots up there wouldn't be what have to require property.
Correct,
That's true.
those are separate lots. I'm just noting what the uses are, that's all. So there's a technical residential use on the adjoining lot, but it's across the road, which is a natural divider. I get- I see.
Well, I don't see any current use to screen that. Should we make it a condition?
You might wanna, you could make it a condition that should there be a residential use that's developed on the adjoining lot, that the screening would be installed.
I would think that would be appropriate. Just to
If
see
you're
why.
inclined, yeah, if you're inclined not to put any screening on it right now.
And that condition would say basically screening as per, as I show it.
Yeah, as you proposed here, yeah.
A little bit cut my cut out for the screening.
Yeah, in the event that there would be a residential use constructed on the adjoining property, on that side, on the east side of Old Trail Road, that then the screening or fence would be put up at that.
Within a 9-foot.
Yeah. Yeah.
I don't think there'll ever be anything put there.
Yeah, I agree with you. I'm
Yeah.
just saying it's
Right, but
it's a specific
just in case.
condition.
If anything, it'd probably be a more.
More, yes.
Yeah,
It's
which you
right there
wouldn't-
on 83, everything's sitting on 83.
Which is why you wouldn't want screening for it. You could end up
I don't know what
actually, you could end up
83's right away is
subdividing.
either, there's probably not much room there.
Yeah.
No, I don't think you have much with,
The interstate right away, there's probably hardly any room there.
So you're absolutely right. It definitely is narrow.
My
The
only,
concern is that that strip to the north, because of the natural division with 83 and Old Trail Road, could be subdivided off at some point in time. And that could be a property that would extend, added on to yours or added on to the north, and those folks to the north start heading south and start putting more apartments or whatnot there, or that's allowed at some point in time by the ordinance. So you have an opportunity now to address that.
well, what I might ask is, do you think that without a buffer, and this wouldn't really be working as a buffer, but your clients would possibly end up walking their dogs or their animals over and using that property to relieve their animals and then cause a problem with your neighbor?
Well, I don't know the answer to that.
You know, I just want, that's,
Yeah, I can't control that, but.
Nope, I
they did
understand that.
They did try tried to approach them to purchase some more land there,
Mhm.
but they didn't wanna sell anything.
No.
It doesn't mean they won't later on down the road.
Yeah. So I'm just thinking for your own good, maybe a little something to let them know that, I mean, that's nothing we can control. We can't control it either.
Yeah, even customers come out there with a dog, take them out of the car, walk over there. and
That's
tell
right,
them where the
that's,
parking lot is.
and the next thing, you got the neighbors coming down and,
Not necessarily a 6-foot fence, maybe a 4-foot fence or something along there.
No, put a barrier, yeah. I'll talk to them about that, and then it would be up to them if they decide to do that, I'm sure.
yeah, that's just a recommendation, that's not, you can just see it down the road.
Well, that raises a host of other issues, okay, so
Well,
you're, denoting where your property line is or where the veteran offices could be of use. But it's
So.
a question of residence.
And a fence, when a fence is put up, it has to be off the property line a certain,
It doesn't, it can go right up.
It can go right on the-
We recommend to stay off so you can maintain behind.
but you can go.
You can't go up to
Okay.
or attach it to your neighbors.
Yeah,
That's
Oh, yeah.
and then they call it the
yeah, because somebody built a fence against their fence.
They wanna pay for that extra
Yeah.
black panels.
Well, I don't know, I would say if you don't need a buffer, don't put the buffer, but if the complaint comes in and you have to put a buffer in.
Must have got a blacktop road.
There's no residence there.
So there's,
Well, but there is a residence across the street that owns that property, right?
Right, I think the concern is what's a complaint?
Yeah,
That's a little bit perhaps subjective.
so a buffer's not required.
Right, it's not even required.
Maybe a division of property might be required down the road.
And if I may, you do have some trees there.
Yeah.
Adjacent lot that could be classified as a buffer, because of the size of the lot and stuff. I mean, it is right there.
Mm-hmm.
And we would consider that a natural buffer, for that purpose. So it looks like it is right there in front.
The neighbor.
I'm looking at the pad,
Yeah, look at that, look at A1.
Yeah,
I'm
there's,
on A3.
Yeah, look at A1, you see the buffer in it,
Yeah.
where the trees are.
Okay.
So that's what it's known for that. So it would be on trees, it would probably be. Brief condition of adding, condition of, comment around is a good decision.
Something in the ordinance.
That's up to you guys.
as far as,
That's your decision.
my only thought would be a condition that if a house was built on an adjoining lot.
Well, you can put that in or not, but not put anything.
I would put it in.
On the east side on the east side of Old Trail Road there, because you're not gonna put a buffer up along Old Trail Road, but.
It would be along the northern property.
Yeah, the
Right.
northern.
The north of your
Like a
property.
northern property line,
Yeah.
if there's a residential use put on there, on the east side of Old Trail Road.
East side of Old Trail, northern side of the
Between
property.
the old trail and the.
83.
Yeah.
Along the northern property line between Old
Right.
Trail and the.
Right. In the interim, to avoid the complaints, that's up to the owner to maintain their property, so they may choose of their own accord to do something to separate the two, whether by further screening or vegetation and et cetera, to note where that ends, to keep folks from wandering out there. It is nicely kept on the other side, so that answers your question about potential complaints there, so. It's a bit of an anomaly in the ordinance. I mean, this is a unique property, the way it's laid out and
Mhm.
divided.
It is very
And there's,
neat. And they are gonna pave that section for
parking is gonna go where the pink is, right?
For the parking in this green area,
Yeah.
this is where we were going to propose the line for parking.
I think the key is that there's no residential use that's allowed in the future on this particular zone. It just happens to be there across the road because they're non-conforming, and it happens to be all the same property, which has probably been that way forever prior to even Old Trail Road going through. So, that's the part of the uniqueness of this application of property. So what's there to buffer?
So as far as the buffer goes, we're okay with no buffer. Unless down the road there's a complaint, or, not a complaint, but a residential
And-
property would move in.
Yeah, my thoughts would be to limit our condition to, if a home were ever built on the adjoining lot to the north.
East of 83. East of 83.
Be west of
north
83.
lot.
It'd be between 83
The
and...
adjoining lot to the north pretty much delineates
Like
it
the
too.
whole
Yeah.
thing.
There's only one lot to the north, so.
Read it all.
I don't believe you
I don't think so.
I don't either.
Not
but-
meet the setback.
Yeah, I don't think so either.
I just feel better about putting it in there. Do we have a motion?
I'll make a motion to approve docket.
Any conditions?
Yeah, putting a fence in, docket number 2005. Putting a fence or screening if it's if it's ever built on the property next to it. Adjoining property to the north.
To the north.
I'll make that motion.
I'll second.
Any discussion? I think I'd like to just add, as per the provided site map that indicates screening, because there's several site maps. One version does not indicate screening, but there is a version that does indicate screening.
I made the motion. You second it, yeah?
All right, all those in favor say aye.
Aye.
Opposed, say nay. Hearing none, the motion passes.
There'll be a written decision within 45 days. If there's a meeting next month, then it'll be issued at the meeting. There you go. You can see, Jeff, in the meantime, regarding the next step in the process for the permits, et cetera. You do?
Huh?
Conditional use? Okay, I figured.
I could have kept mine separate, I was trying.
I lost some.
We will now hear docket 2006. Adrian Stahl, 1630 Ernie Road, Dover, PA, 17315. Applicant has filed a request for variance from section 303.3 design standards to reduce the minimum required rear yard setback from 6 feet to 3.5 feet and the side yard setback from 10 feet to 1 foot in order to construct a pole building garage. This property is in the rural residential zone at 1630 Ernie Road, Dover, PA, tax map OG, parcel 22A. Mr. Martz, you're already sworn in. Was the property posted?
The property was posted, it was advertised on August the 5th, 2020. It was also advertised in the York newspaper company, August 5th, August 17th, as well as the Newberry Township website, the Newberry Township Administration Bulletin Board, and the surrounding areas.
Is there any additional information for the board?
I have none at this time.
Could you raise your right hand and repeat after me? I swear to tell the truth, the whole truth, and nothing but the truth, so help me God.
I swear to tell the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Could you go to the podium, please, and state your name and address for us?
Good evening, gentlemen. My name is Adrian Stahl. I'm the applicant and property owner of the said address on docket 20-06. I am requesting a variance to build a pole building style garage to reduce the minimum setback from obviously 6 feet from the rear to 3.5 feet, and then 10 feet from the side down to 1 feet. Some specific characteristics about my property: it's a very small lot. It's 0.29 acres. And then with the home itself, it's a small dwelling at 1,008 square feet. And I trust that everybody got my packet, my application with all my supporting documents. I'm not sure what questions you have of me of the building plans. I just provided them there from the builder, but I can move on to the, it'd be pages 9 through 11. It's the property tax map information.
If you don't mind, we can just get some basic information.
Okay.
So if you're facing your property from Ernie Road, what would be to the north of your property?
The north would be across the street, like across the street from the front of my property. So the south would be the back end, the back of the property.
Well, what's across the street?
Another residential homes.
Okay. And what's to the rear?
The rear are two property, or the rear, there's one property, and he has an L-shaped property that gets directly behind me and then goes to the northeast, and then the side property goes, actually his father owns the field to the side of the property line, and then he owns everything from there up to the old white church at the Y in the road.
All right, so that's all field up to the church?
Yes, well, there's a field, and then there's my neighbor's house and his garages, and then he has another field on the other side of the garages,
All right.
and then it's the white church.
And then to the other side, the
The rear.
L-shaped one, is that a residence, or is that just,
Are you saying it's to the rear?
you said, yeah, to the rear? Is
Okay,
that
to the
was-
rear, that's my other neighbor,
Residence?
that's his son, and then his house is actually off of York Road.
Okay.
And the structure, I didn't measure it, apologize about that. It's gotta be at least 75 to 100 yards from my rear property line.
Are you on public water or?
Yeah, everything's private.
Well,
Private well, sewer, everything.
Septic?
Septic, yes.
One-story home or two-story home?
It's one story.
One story.
It's built in 1945.
Wow. pictures here of a foundation, what are those?
Those pictures, they
Appears-
predated me probably before I was even born. I assume they were from some sort of barn or structure that used to be there, but it was not there when I bought it in 2007.
Oh, okay.
The proposed pole building is gonna go, it's not gonna be the exact footprint, it's gonna be, it's gonna be 3.5 feet from the rear of that wall, and then it's gonna be just inside the wall on the side, which is exactly 1 foot from the property line to the inside of the old block, which it's gonna come out when, if construction can start.
So that's an old barn. So if I heard you correctly, that foundation structure is not there today? It doesn't exist?
The foundation?
Yes.
Yeah, what you see there, that's what there, I started ripping out the one side, and then
Okay.
back in the other side by the satellite dish are still there.
Okay, so that foundation still exists?
Yes,
And that's the location where you want to put the pole building barn? a
Yes.
garage. Okay. What size garage?
it's a 20 feet wide by 30 feet long, 10 foot tall. It's gonna have an 812 pitch roof.
Metal construction or wood frame?
Wood frame or pole building style frame that's gonna have metal siding, metal roof.
For two-car garage, or is it one car plus
It's,
storage?
say again,
One car and storage, or two-car garage?
one car and storage.
That's gonna, okay, I got it.
And I did do the best I could with drawing in on the county tax parcel. Provided the original, and I provided a copy of it where it's kind of hard to see on the color ink. A better picture is it's my original septic designs when the septic was put in 2007. So the first page is the original, and then the second page I wrote in where the proposed pole building will go.
Sand mill?
No, it's pressurized aggregate, and just, I want to put one thing on the record, that Mr. Fink, his company put it in, just that, because if you have a question for how it works, I would say direct them to him. And I did measure from the side property line, or the proposed side line of the building to the edge of the drain field from the rear. If you turn to the second to last page, picture number 11. And then on the lower part of the picture, you can see I circled the flag markers for the north side of the garage. And then up towards the top center of the picture, you can see the small markers. That's the edge of the septic drain field. And then the last page is a reverse picture from the septic over where the garage is.
So you're limited to where you can put the garage because of the septic drain field, basically, right?
Yes, correct.
Your drawing here shows an existing shed.
That was an existing wooden shed when I first bought the home. When I moved in, I literally knocked it over, like I pushed it over with muscle powers.
That's where the pole building is going to go.
Correct.
Garage, down
Correct.
that corner. I assume you're extending your driveway back to the garage?
Yes, I
Just
think it
gonna
was
go
extended, I
straight.
think it's either 10 or 12 feet from the current stone driveway. And I did measure the distance from the drain field pipes to the edge of the proposed building. So the southwest, when you look on the second supplied map of the septic design, the top, from the edge to the top pipe is 18 feet and 6 inches. And then the bottom pipe, which is the southeast corner of the drain field, would be exactly 21 feet.
That's between the septic and the shed, the new shed.
Yeah, where the proposed, foundation would be, correct.
I assume the neighbors know you're building this,
Yes,
and they're not here to complain,
yeah, they're definitely not here.
Yeah, so they're not here, so.
so.
That's funny, I was thinking the same thing over here.
That's what I was
Well,
gonna
yeah.
say,
I need your consent on a few items to continue.
You better buy
That's
something.
the
they,
second time.
he needs to buy some.
All right, that's good.
Well,
Everybody outside waiting to testify.
Nope, I have no witnesses.
No witnesses, no rebuttals.
Well, considering there's previously been a structure in the same spot, basically. And there's not a lot of places to put it.
I don't see it's a big place.
And it's not like you're trying to build a 3-car garage.
No, it's pretty simple.
Well, I would like to make a motion that, since there's no one here to dispute what he wants to do, no one complaining about it, that we accept his proposal.
I'll second it.
Okay. I'll second it.
Brent, second.
Is there any further discussion or
Suggest a condition that.
Conditions?
I suggest a condition that the variance be granted with the setbacks no less than as proposed. Okay? So if he chooses to make them a little broader, that's fine,
But no less.
no less than the 1 foot and no less than
Thank you.
3.5 feet. Yes, 3.5 feet. Okay?
would you like to amend your motion?
All right, we'll accept, we'd like the motion that we accept Mr. Stahl's proposal as proposed, that he will not make his setback any smaller than noted on the drawings as such.
Oh, I'll second.
All those in favor say aye.
Aye.
All those opposed, nay. Hearing none, the motion passes.
You're sitting there, so.
Thank you, gentlemen.
Thank you, sir.
You wish you could've been first, right?
We're sorry about that. It's just,
Do we have any other business? Do I have a motion to adjourn?
make a motion to adjourn.
I'll second.
All those in favor say aye.
Aye.
Opposed, nay. Hearing none. This meeting of the Newberry Township Zoning Hearing Board is